Hey everyone, welcome to this month's installment of the Bracewell Environmental Lands and Resources section Environmental Essentials webinar for in-house counsel and others. This is Tim Wilkins, partner in the Austin office, joined by my colleague Daniel Pope, and we're going to be talking on Environmental Auditing 101, how environmental compliance audits work and why they matter. By way of introduction, I'm going to talk a little bit about environmental compliance auditing generally, how those audits work and some of the benefits of auditing in its own right. Daniel's going to talk about some of the specific audit programs that are out there, audit privilege, audit disclosure, federal and state levels, as well as some of the key features of environmental audits. And then we'll both talk a little bit about some of the benefits of strategic auditing. I'm going to go ahead and dive right in on the discussion of what environmental compliance auditing is all about. Environmental auditing, compliance auditing, is an internal process to voluntarily discover and correct environmental compliance issues before a federal or state agency commences enforcement. This is to be distinguished from, for example, an agency coming and conducting an inspection, or an agency conducting a file review. This is not about the agencies doing the audit. This is about a self-audit that's conducted by a facility or a company trying to identify its own potential compliance issues and get ahead of those. This is also distinct from required auditing that may take place. I'm thinking, for example, of RMP, PSM, triennial auditing that are a required feature of that suite of regulations. This is about doing voluntary audits, voluntary checkups on your own compliance. Some states, and of course EPA, have formal audit programs that offer incentives to companies that participate in these audit efforts. But audits can also be just performed in their own right. Think, though, about what you're going to do in terms of how you would approach that audit, whether that would be done by internal staff, by a third-party auditor, whether that would be conducted under some form of privilege to protect against the use of any of your findings as evidence against you, and so forth. Thinking about the benefits, why would one do this? Well, first of all, I think you can really use environmental compliance auditing as a way to minimize your enforcement and litigation risk, because you are, again, voluntarily, systematically going through your operations, your activities, your permits, your requirements, and trying to determine if there are any gaps out there. You're trying to identify those issues and to correct them before they become a bigger problem. The benefits of the environmental compliance audit effort, though, really depend on the program. If you're talking about audit disclosures, and that can include penalty reductions, that can include outright immunity. There are other features as well where you can get other benefits from agencies if you are doing an audit under one of those programs. But separate and apart from the EPA Audit Policy or the Texas Audit Privilege Act, one of the key benefits is just really understanding your compliance posture, where you are, what you might be missing, and how you can get out of that hole and get things fixed so you are facing fewer risks and fewer concerns. In the state of Texas, there's also an added benefit of if you do an audit, it actually improves your compliance history standing, at least for noticed audits and audits where you file any kind of audit disclosure. I'm going to hand it off to Daniel when we talk about these various programs, EPA and state programs for environmental audit, privilege and disclosure and so forth. He's going to dive into some of those aspects.
Thanks, Tim. And before we jump into the specifics of EPA or Texas or other state audit programs that may be out there, I thought it might just be worth a minute or two taking a step back and thinking about why in the world would an environmental enforcement agency develop and implement an audit program, right? One of the things that we're talking about here when we talk about environmental compliance auditing is taking your own people at your company and sending them out to your sites, your facilities to diagnose your environmental compliance status. If you weren't performing that work, it would be up to the state or the EPA to commit its own resources to getting its inspectors out there, to going through your records, to going through your facilities and finding what kind of violations might actually be occurring. One of the benefits of environmental auditing from the perspective of environmental enforcement agencies is that through these programs, you've just leveraged hundreds, if not thousands of people to go out and do good environmental work in finding potential compliance concerns and correcting them before there is a more significant release or a more significant incident. So what I'll talk about now is how EPA and some states, and we'll be looking at Texas, have come alongside the concept of environmental auditing, have developed it into a program, and what some of those program requirements are. I'm going to talk about specific programs first, and then I think because those can be a little bit too detailed to really handle in a 30-minute webinar, I want to leave you guys with a few standout features, threads that we can draw across federal and state audit programs so that you and your in-house counsel role can have some guardrails up or some triggers that help you think about when an audit might be helpful to your team. The first audit program that we'll discuss are the United States EPA's compliance audit program. This is incentives for self-policing, discovery, disclosure, correction, and prevention of violations. EPA published this in the Federal Register, almost 26 years ago. The audit policy here is that through disclosure of violations and their correction, people who participate in EPA's program can receive significant reductions in gravity-based penalties and a commitment from EPA not to refer violations for criminal enforcement. If you participate in EPA's audit program, you're not necessarily eligible for complete immunity, although sometimes you can receive complete immunity or at least a reduction in the penalty amount to $0, and then other benefits as well. But there are important conditions that come alongside participation in EPA's environmental compliance auditing program. If you're going to be eligible for the benefits of the program, that depends on you meeting several conditions. There are 9 total, but simplified here, we've got 6 main ones. First, that you have undertaken systematic discovery of environmental violations through an auditing or compliance management program. You've discovered your environmental violations voluntarily. Tim was talking about that a little bit earlier, where there is some sort of outside pressure or outside driver to your discovery of an environmental violation, whether that's an RMP audit or the need to prepare a deviation report. That's not exactly a voluntary discovery of an environmental violation. You're supposed to be doing that anyways. But in other contexts where you have gone out and performed a voluntary audit, that you've discovered this environmental violation as part of the audit. That also means that you've discovered the violation as part of the audit. You didn't know about it beforehand. Then prompt disclosure to EPA of that environmental violation, usually within 21 days, timely correction or remediation of whatever compliance concern you've identified. And then a couple of important things to continue being eligible for those penalty reductions. You need to prevent the violation from recurring again within a period of time. So you can't fix it on day one, disclose it to EPA, say, I would appreciate my gravity-based penalty reductions, please. And then on day 2, you've got the same problem all over again. It truly is a permanent solution to whatever violation you've identified. And then finally, the disclosed violations that you are surfacing to EPA are not sort of chronic or repeat violations at the facility. One, that raises questions about whether you really discovered them as part of the audit. But then EPA doesn't want to incentivize facilities or companies to not address issues timely when they know about them. They want you to address them right away if possible. There's also a really interesting audit policy that we do a lot of here, Tim and I do, called the new owner audit. This is EPA's interim approach to applying the audit policy to new owners. It has been interim for a long time. It is their policy. The new owner audit program offers companies that acquire new companies to disclose and correct pre-acquisition violations that they discover at those new companies, at those new facilities. When they're bringing a new company into their portfolio, companies have an opportunity to go in either through the diligence process or through an audit period immediately following closing to discover environmental violations at that new subsidiary, at that new affiliate, and correct them. EPA wanted to add the new owner audit policy to its existing audit program because it discovered that the first audit policy, the compliance audit policy, was frequently used, more frequently than not used, to address record-keeping gaps or other other issues that did not necessarily result in reduction of emissions after the corrective action was all said and done. New owner audit is a great inflection point in the growth of a company to go through and achieve really serious emissions reductions, really serious corrective action for any violations, again, discovered during that diligence phase or discovered within a period of auditing following closing.
Hey, Daniel, before we leave the new owner audit piece at EPA, I mean, I think with all due modesty, this is something that we've done more of than anybody else in the country. And I think it's really useful to understand that this works not only in the context of an asset acquisition where you buy a facility, but where you buy a company, where you buy the equity, where you buy the stock. In those latter contexts, you are succeeding to the penalty liabilities for all of the bad stuff that target entity did before you acquired it. Being able to extinguish those liabilities, those penalty exposures, can be really huge. We have done this on more than $100 billion worth of deal value. We've done audits in that context and saved companies literally hundreds of millions of dollars in likely penalties. I think this is really important to understand. And I think it's important that you don't have to get this audit done right away. You have the ability to very quickly enter into a letter agreement with EPA that gives you more time to do the audits. It can be a really flexible and functional process that matches up with how you want to integrate a new acquisition. So really, really worth taking a peek at the new owner audit if you are at a company or representing somebody who has acquired a company or a facility.
And at the risk of turning this webinar into a new owner audit only webinar for the remainder of this episode, I think one of the other cool things about the new owner audit, and Tim, we've done work with this, is on the front end, if you're buying a facility or you're buying a company and you know that you might want to do a new owner audit that is going to surface violations that you then are going to have to fix, you can incorporate that into the transaction itself. You can allocate those risks or liabilities thoughtfully with your counterparty when you are buying this company or this asset. You say, I'm going to go do a new owner audit. This benefits both of us because we're going to be discharging a lot of liabilities, but there are still going to be costs. How do we want to allocate those? I think it's if you're in an in-house counsel role and you're learning of those deals as they emerge, I think is a great opportunity when you think you might be buying something that has a little hair on it, that it may have some violations in the closet, right? That you can go in to your deal team and say, hey, let's put a dog ear on a new owner audit and see what comes up. Let's jump down back into the state audit programs. Here we're going to be focusing on the Texas Environmental Safety and Health Audit Privilege Act. We just call it the Texas Audit Act because that is a mouthful. Before I jump into the details, though, I think it's worth mentioning that across the country, there are some states that have adopted similar audit programs through a statute. You have state agencies that may have adopted audit policies. As you're considering where and when and whether to engage someone to perform an audit at one of your facilities, it's worth taking a look at, hey, what's available in Oklahoma? What's available in Montana? What's available in Pennsylvania? Not all states have these, right? But those who do, I think, benefit from, again, the self-policing and the self-corrective action that these audit programs incentivize. So here in Texas, we have this Texas Audit Act. It allows for complete immunity, so zero penalty for violations that are discovered and disclosed and corrected. Under the Texas program, a company would submit a notice of audit to the Texas Commission on Environmental Quality or the Railroad Commission to begin an audit process. There's a 6-month auditing period. Then there's a period where you can disclose over the next 6 months. I think that can be really handy for identifying a violation, but then strategically thinking about what your company wants to do to correct that violation. More on that in due course. And then a 6-month corrective action period. So we see some similarities to what we see with EPA, right? Voluntary discovery of an environmental compliance concern, disclosure of that, and then corrective action. Companies can discover, disclose, and correct violations of state environmental requirements. Of course, that would be obvious. But one thing that's interesting here is that under the Texas Audit Act, you can also identify, disclose, and correct violations of federal programs where those federal programs have been delegated by the EPA to TCEQ or to the Railroad Commission where applicable. So it is a way to look at compliance with certain federal requirements, again, when there is a state delegation at play.
Before we move on from the state slide here, if we were sitting here 3 years ago, sort of in the vicinity of Texas, we would be the one state that had a really formal Audit Privilege Act, audit disclosure program. Shout out to Louisiana and Oklahoma for adopting audit statutes, and in the case of Louisiana, regulations that provide for similar relief. Oklahoma is like so similar as to be scary. Louisiana's got its own wrinkles. And the state of North Carolina actually adopted a new statute in 2025, I understand. So there's lots of movement continuing on this. Most of these statutes and policies came online in the mid-90s, but they continue to grow. They continue to show up in different places. So keep your ear to the ground on new potential audit opportunities wherever your fleet may take you.
And to follow on at that, Tim, as more audit programs are adopted, I think it's worth taking a moment, having discussed the EPA compliance audit program, the new owner audit policy, having discussed the TCEQ's audit functions. For in-house counsel, instead of just, memorizing all the aspects of those audit programs, there are some key audit program features we want you to keep in mind so you can, as you're going through your day, as you're hearing of new issues or new concerns, you have some basic ideas, a basic framework for what environmental compliance auditing is generally. And then Tim and I can help you tailor that to a specific program. First of all, audits have to be voluntary. Unless they're, except in certain circumstances, violations that are surfaced through compliance monitoring obligations that are imposed by statute, by regulation, are typically not eligible. Tim and I can go into more detail on that with you at a later date. But generally, what EPA and the states want to see is that you have taken some initiative to go through your own facilities, to go through your portfolio and search for potential environmental violations. Violations have to be discovered through the audit. A company cannot have knowledge of a prior violation of an environmental requirement before they commence the audit and then hope to disclose that same violation for penalty relief. Sometimes Tim and I will get calls. Hey, we found this. Can we do an audit? Well, if you've already pretty well characterized the environmental violation, that violation is typically not going to be eligible for an inclusion in an environmental disclosure to EPA or a state agency. But, and this is a really important but, if you discover a violation at a site or you hear of a violation at a site, those violations usually don't happen in isolation. A discovery of a violation can be a sign to kick off a formal audit to discover other violations or to take a closer look at another facility. So even if you can't discover the audit precipitating violation and include that and get penalty immunity for that, you can take a hard look at other facilities in your portfolio that may have had similar issues, or you can do a more comprehensive search of that facility where the violation occurred.
This merits a little bit of extra color here. If you've got a situation where a facility has said, man, I don't know what's going on with this program, it seems like it's disorganized, you do not yet have knowledge of a violation, you can say, I'm going to audit that program. If you have somebody come in and say, well, here's the smoking gun, we know we exceeded this limit or we failed to submit this report, it's probably too late to do an audit and make a disclosure for that. But there's a lot of gray in between, and you can tailor an audit to an area that you've got a concern about. You don't need to do a multimedia audit of every federal and state statute, regulation, permit program in order to qualify this. You can say, man, I'm worried about air compliance at this facility. I'm going to do an air specific audit or a state air requirement specific audit at this facility and, build this eligible audit around things that concern you.
Right. I think of the notice of audit or the kickoff of an audit as being very cortisol dependent, right? When you have that stress start to build up, you don't know where it's coming from. Or, you could think about it as a spidey sense, right? Like, I don't know exactly what the threat is or what the risk is, but I feel like I need to look closer. That's the moment that you start thinking about kicking off an audit.
That's when you send in that notice of audit so you don't accidentally discover something before you've qualified for the Texas Audit Program.
Exactly. So disclosed violations have to be successfully corrected within available timeframes, right? And that makes sense. The point of providing penalty reductions or penalty immunity is not so you can sort of persist or slow walk corrective action. There are deadlines to complete that corrective action. And agencies are fair to expect that. But they're also willing to work with companies to accommodate reasonable delays. This includes consultant-related delays. They couldn't get out. They were snowed in from a freak winter storm that hit in late January. Contractor-related delays, long lead time equipment. We often see that when an audit has been performed that discovers that, we need a permit amendment, so we're going to have to send in an application. That's going to take a lot longer than 6 months. Well, agencies are really willing to accommodate those very ordinary types of delays with extensions or some combination of an extension and then a regular update that you would provide to that agency. Again, people that run audit programs at state agencies or at EPA are happy that you've engaged in this work. They want to make sure that this is a win-win for the environment. So understanding these key features can help you guys as in-house counsel more readily take advantage of these audit programs and know sort of what the guardrails are and when you want to engage an audit function, when you want to reach out. One of the things that Tim and I do really regularly is leveraging audit experience across a broad array of clients and companies. And through that, we've developed a relationship with key people at EPA and at TCEQ. And that really helps us accomplish your goals in a more specific way. Tim, why don't you talk about some of the benefits of strategic auditing? And when I think about strategic auditing, we've talked about immunity, we've talked about fixing problems before they become large, but I think that there's another way that we should talk about environmental audits, and that is how they fit into a company's core objectives.
Yeah, I think that's right. I mean, I think the idea of an environmental compliance audit is not this one-size-fits-all thing. Conceptually, you are going to evaluate your environmental compliance against the requirements that apply to your facility, that apply to your company. And it allows you to think about how can I improve my environmental compliance function. That is all like really crucial. But again, it can be bespoke. It can be tailored to specific programs or issues that you're concerned about or that you've had historic trouble with. But all of this can be designed to meet your individual company needs. Do we need fresh eyes on it from another facility in the fleet? Do we need fresh eyes on it from a third-party vendor? Is this something we're very concerned about potential findings, and so we want to put it under attorney-client privilege or just rely upon state evidentiary privilege requirements? I think there are options out there. But all of this allows you to check out where you stand, your compliance status, and develop strategies for getting better without waiting on EPA or TCEQ or whichever the other agency is to begin enforcement against you. You get ahead of it there. And this is a really robust opportunity, really robust tool for helping you confirm that your internal compliance efforts are successful. It's not just where do I stand on compliance, but hey, is there something I could be doing better programmatically internally? This can help you diagnose that. And maybe it's not even, I'm not complying. It's just somebody's auditing me and I'm having a hard time proving that I'm complying. What can I be doing better so that the next time an inspector shows up, I just drop a pile of paper in there and they go, wow, obviously you're doing this correctly. Auditing is this huge opportunity to strategically build up the most robust and useful compliance program. It is great to make sure that your environmental management, your EHS management, is on top of things, but it also brings along juniors who may not have experience with all these programs. When you help identify things that may or may not be compliance gaps, but are things that could be done better to demonstrate compliance, it's a real learning opportunity. But The biggest piece of this is if you are doing a voluntary audit, you have the opportunity to identify and correct any big concerns before they become big enforcement problems, before they spin out into bigger compliance problems that are harder to avoid or that require disclosure. Again, you can also be very strategic about this in that you can pair it with your other business initiatives. If you are integrating an acquisition, environmental auditing is a great way to learn the EHS systems, EHS practices of the target that you've acquired. You can pair this with building out better standard operating procedures to make sure that your procedures are really fine-tuned towards the compliance objectives that you have. It's really an interesting and important opportunity. Really encourage people to take advantage of periodic environmental compliance auditing on a voluntary basis as a way of making sure that what you're doing is working the way you intend it to.
And Tim, one other thing that I have loved about working on these audits with our clients is that when we've identified a violation and when we've started to think about, okay, well, how exactly do we want to correct it? There's a lot of freedom in that moment to figure out what corrective action strategy or what corrective action plan works best for the company. In compliance audits, companies are going to design and propose corrective action plans to EPA or to TCEQ. And that's really different from the enforcement setting. In the audit, the company is in the driver's seat. Yes, you've identified a violation, but you actually get to say, and this is how I want to correct it. That's very different from when you're responding to a notice of violation from EPA or TCEQ, where they've expended their own resources to find violations at your facility. When they do that, they have already committed themselves in many ways to their own goals for what compliance at your facility looks like. They are not thinking about the longer term business objectives for a particular site. They are not thinking about whether you want to upgrade that process anyways or shutter it. They are going to say, this is what compliance looks like and this is what you have to do. And you lose a lot of flexibility that way. And so I think that another strategic benefit of auditing is taking a hard look at what you're doing at your facility and designing a corrective action plan that looks right to you. And then when you submit that to EPA or TCEQ, again, they are appreciative, and Tim and I have had these experiences. They're appreciative of how you have taken initiative to identify and fix violations. And they're going to be more receptive to that plan than they would be if they were enforcing against you for those same violations.
I mean, I'm thinking about sitting across from Pat Foley at EPA on, air consent decree negotiations about injunctive relief. And EPA's position is like, no, you're going to do the following corrective actions. You're going to install these controls. If you're finding and doing this through the audit, you get the opportunity to say, you know what? There's a process design change that I've been thinking about for some time. And maybe I could incorporate that here and actually capture some of those emissions and reroute those to product. Maybe I could do something by adjusting throughput here or changing process or chemistry there. You have the ability to design a path to compliance that looks very different from the kinds of things that EPA and even to some extent TCEQ are likely to order in an enforcement process. And so I think Daniel's observation here that you kind of are in the driver's seat when you're doing this corrective action through the audit process instead of through enforcement, it really, really rings true to me. Well, Daniel, I think just to wrap this up, I think our message is that periodic, targeted environmental compliance audits are a really powerful tool. They create this opportunity to use state and federal audit laws and policies to minimize exposure and risk. And if you're strategic and thoughtful about them, they can really be designed to pair up and improve what your business objectives are, not just your compliance objectives, but to think more broadly about what am I doing here and how can I make things easier for me and everybody part of this organization on a go-forward basis. It's a really powerful tool. Really encourage people to reach out and ask questions. If you ever want to just brainstorm a little bit, reach out to Daniel, reach out to me. We'd love to talk about opportunities in this space.